This is the beginning of Lecture 3, Legal Research and Methodology. Why do we do legal research? Well, legal research often determines the outcome of a criminal case. There's 4 types of legal research: locating a particular case, researching or locating all cases on a particular topic or subtopic, checking the case or case to see if they've been superseded, or reading a particular case and writing a legal brief on the case. Judicial review. The Supreme Court has the right to review laws that have been passed and to overturn those that violate the Constitution of the United States. So if the legislature passes a law and it's unconstitutional, it won't pass judicial review. The Judiciary Act of 1789. This was basically the precedents for being able to overturn illegal laws that violate the Constitution. Basically reads it, where the validity of the statute is questioned on the ground of being repugnant to the Constitution, meaning in violation, or the construction of any clause of the Constitution may be re-examined, reversed, or affirmed in the Supreme Court. Laws can't be vague, and they can't violate any of the Bill of Rights. The first case where the Supreme Court overturned a law passed by Congress was Mayberry v. Madison, important to know for testing purposes. 1803, Justice John Marshall declared a constitutional act in conflict with the Constitution, a congressional act in conflict with the Constitution, and therefore made it void. This was the precedent for judicial review. It meant that the Supreme Court could overrule a law passed by Congress. Fletcher versus Peck was in 1810, soon not long after, and the Supreme Court declared that a state law was unconstitutional. This set precedent for judicial review over all of the states. The Constitution means what the Supreme Court says it means was basically what came out of that. Remember that precedence is again where decisions are made on previous court decisions. Judicial review of lower courts. The California Constitution provides for judicial review of trial verdicts by the lower courts. The appeals have to be based on a couple of things, either improper courtroom procedure or errors, or number 2, a violation of the defendant's rights. It only takes a majority vote to overturn or uphold a case. So most of the appellate courts, or all the appellate courts, are made up of an odd number of justices so that there's no ties. Precedent, also known as stare decisis. Basically, it's important to understand that a court often makes its decisions based on previous court decisions called precedent. Courts, especially intermediate appellate courts, try to rule consistently with past decisions in order to maintain an orderly system so that people will know what conduct is permissible and what is not. We're going to talk about the structure of the courts, and I'm using California and particularly Contra Costa County as a basis, since that's where my college is located. If you look at the slide at the bottom of the totem pole here, we have the District Superior Court. Used to have municipal courts that handled misdemeanor trials, felony pretrial hearings, and civil claims to $5,000 and large claims to $25,000. That has been eliminated, and currently these are called District Superior Courts, and they're able to hear felonies. Each county has a superior court. In Contra Costa and Martinez, they handle felony trials, specifically the murder trials. They have a separate area, separate court system, little mini system within the Superior Court that handles juvenile cases, and they handle civil cases over $25,000. Now, the Superior Court, these are trial courts. They deal with questions of fact. They determine whether somebody is guilty or innocent. Next up on the line would be the District Court of Appeals, District 1 in San Francisco Bay Area, the Appeals Court for Bay Area Trial Courts. If you are going to contest, complain, cite that there's an error in the handling of your case, you would make an appeal to the appellate court. First stop, District 1 in San Francisco. If you're not satisfied with the outcome of that case, it can be appealed to the Supreme Court of California. They only hear appeals in cases from trial courts and from the other appellate courts. They handle death penalty cases also. Now, if you look at this graph again, or display, the bottom two again are trial courts. The top two are courts that deal with appeals only. They deal with questions of law or errors. In the federal court system, you have the U.S. Federal District Court, which is a criminal trial court, much like the Superior Court. Now, the next step up is the U.S. District Court of Appeals. There's 12 districts. They handle western United States, so it's like California, Oregon, Washington, New Mexico, Idaho, Utah, Hawaii, and a number of other states. But there's a total of, I believe, around 10 states in that district. This court is the first stop on the appellate route for the U.S. Federal District Court, and it is also a stop after a state Supreme Court. So if we go back to the previous slide where you have the California Supreme Court, you're not happy with the decision made by them, your next stop would be the U.S. District Court of Appeals. However, if you're being tried by the FBI for interstate transportation of stolen property or vehicles, and you get convicted and you want to appeal your conviction, your first stop would be at District 9, U.S. District Courts of Appeals. And then the highest court in the land would be the U.S. Supreme Court in Washington, D.C. Case law and its uses. Courts, by their decisions in criminal cases, frequently define the meaning of words, phrases, and terms found in the Penal Code and other codes describing criminal offenses. And an example is, in burglary, what's the definition of a structure? Well, a structure is usually has 3 walls, a roof, a floor, a door that's lockable, and then we would get into things like if someone stole your lawnmower out of your garage with the garage door open, would that be burglary? The answer would be yes. That is a structure. But if they stole it from your carport, which has a roof and no, maybe just 2 walls, it doesn't have the 3rd wall, it doesn't have a front door, that would not be burglary, and that would be found in case law. Decisions of higher courts. Again, I said that the appellate courts always have an odd number of justices, so we're not going to have any ties. Case law, the case citation. If you go to a law library and you're going to be looking for a particular case, there are a variety of ways to find it. The old way, of course, is looking it up by hand, and we're going to give you that info now. If you look at the citation I have on this slide, which is People v. Roe, comma 21, comma Cal Apt, comma 3rd edition, comma 114. The breakdown is as follows. People v. Roe are the parties involved. 21 is the volume, so if you went into the library, you'd look for volume 21 of the California Appellate Reporter, which is the reporter that it's in. And when you open that volume, you're going to go to the 3rd edition. Usually it's going to be divided by 4 parts for different parts of the year. Look for the 3rd edition, turn to page 114, and you should find your case. Although you must understand that different cases can be found in a multitude of different reporters. So by case citation, you go to the volume, look it up. If you have the name of the appellate, you can go to the reporter that covers that particular time, say 1993. You got to have an approximate date. You can look in the front, look alphabetically under the name of the parties involved in the case. When you know the type of offense that's committed and you're looking for, say, definitions under burglary, maybe someone breaks into a display cabinet and they're being charged with burglary, and you want to find out if there's any precedence in this, then you would look under the statute and look up the case listed numerically by offense. In this case, it would be 459 PC, which would be burglary. Or if it would be robbery, it would be 211 PC as listed in the slide. When you know the offense and some special condition that you need to look up, you can do that under the California Digest under a topical heading like armed with a sawed-off shotgun, or with intent to commit rape, or some other special condition that exists. You can look under the type of crime committed by the statute number and get a brief description of cases to see if they're similar to the one that you're dealing with. You can go to the blue and white book, which would be used for cross-referencing a case. And what that does is, let's say we're looking up a case like Gideon versus Wainwright. It might be in 3 or 4 different reporters. The law library that you're currently doing research in only has a certain amount of money and may only have one certain reporter, and so you need to find out by cross-listing if it's in that reporter and if you'll be able to find it. Shepard's citation case, it's a method used to keep track of whether a case is obsolete. Whatever is the most current case is the one that would have precedent. Internet-based research, to be honest with you now, most legal research is done right in the attorney's office. FindLaw.com, CalLaw, Westlaw, there's a number of different companies that are out that will sell you databases with all the case files on them, and you can enter the name of the case or a topical entry and it'll find the information for you. Some of the companies charge you for online time when you use their databases. Others just let you purchase the CD-ROM as a package. Basically, the reason that you're going to write a legal brief, and learn how to outline a case brief is because an appeal lawsuit's been initiated because one of the parties involved, usually the appellant, wishes to dispute or to contest the adverse ruling or an inferior court, a lower court. To justify the appeal, the appellant, through an attorney, takes issue either on, for example, a point of law, a constitutional violation, or insufficiency of evidence, or a procedural error that's been made by the trial court. And so what you need to do is look for precedents where the rule has not been followed, and then present this to a judge. A judge is not going to read a whole case, which could be 40 to 140 or more pages long. They just want the facts that pertain to your particular issue of appeal. So, the purpose of the legal brief is to allow a person to quickly find important parts of a particular case. How's it done? By organizing the information in a standardized fashion and by summarizing the information in your own words. Step 1, you need to read the case entirely and get an overall view of the case. This will help you to organize it and summarize in your own words. Once you learn what the format is, I suggest that you take a highlighter and highlight those areas that you're going to need to extract. Step 2, the face page. Basically, for the most part, any of my assignments, you need to make sure you have your name, the class, the instructor's name, the date and time reported. That's basically for colleges, but For the purposes of a case brief, you need to have the name of the parties involved in the center of the page and the case citation below the party's name. Step 3, parts of the brief. There's an outline form. First is the title, names of the party, followed by the case citation, the court that ruled on the case, and the date of the decision. Next is the type of case, a brief overview of the charges that were brought and what happened. The person's convicted and sentenced or what have you. Next is the facts of the case. Major facts of the case, no names other than the use of appellate or defendant. You could use, usually most people will use D. D did this or D did that. Witnesses would be W, and you don't really need names. The information's already been verified by the court. In those documents, all you need to do is explain to the judge what the issues are. Next are issues. There's two arguments. There's the defendant's argument or their contention, and there's the prosecutor's argument or contention. So D's contention and P's contention, another way of abbreviating. Next would be the rules of the decision. This it's answers to legal questions posed under issues section by the court. In other words, what is the law or precedence that is being cited here? Is there a penal code? Is there a previous case? Discussion. This is where you get comments from the justices. What did they think? Why did they make their decision? It can also contain a dissenting view or a contrary view. This is usually done by the justices who voted in the minority on the case. And last thing is the holding or the finding. What did the court do? Did they overturn the decision? Did they uphold the decision? Did they send it back to the court for a new case? Because that could happen too. Attorney General's opinions. In instances where there's a question about the application of the law, where someone has not yet been arrested or tried, the Attorney General can give an opinion, and they publish this opinion, and that's usually what we work on. Key terms for this lecture: judicial review, the Judiciary Act of 1789, Mayberry versus Madison, Fletcher versus Peck, precedent, stare decisis, case law, case citation, appellate, legal brief, D's contention, P's contention, rules of the decision, holding, and Attorney General's opinions. This is the end of Lecture 3.